everyone. Today we will be talking about termination of employment. In this topic, we will know what will be the reasons for such termination. First, we have here the closure of establishment and reduction of personnel. In this scope, we will be discussing 3 points. We have labor-saving devices, meaning these are tools, machines, or equipments designed to reduce the amount of manual labor required to perform a task. Another one is redundancy. This is the state of being no longer needed or useful, especially in employment where a job position is eliminated. The last one is retrenchment, meaning the reduction of costs or spending in response to economic difficulty, which often involves layoffs or downsizing. Also have here the Article 299, or known as disease, as ground for termination. This is when the employer terminates an employee's service who is in a state of disease which is prohibited by the law or prejudicial to his health as well as to the health of his co-employees if the employment continues. However, the employee under in this state must be paid a separation pay to at least equivalent to 1 month salary or to 1/2 month salary for every year of service, whichever is greater. And also at least 6 months of work is considered as 1 whole year. Similarly, there are what we call authorized cause in general, meaning these are legally acceptable reasons for terminating an employee's contract. Sometimes these reasons are usually defined by labor laws and regulations like company restructuring, economic downturns, redundancy due to automation, and etc. There are also many other authorized causes, like the various specific reasons that can legally justify an employee's termination beyond the general ones. Examples of these are misconduct, poor performance, health reasons that prevent the employee from performing their job. In relation to payments, we are all familiar with separation pay. It's the compensation an employee receives when they are terminated from their job for authorized causes. It is actually a form of financial support to help them or the employees transition during unemployment. The amount is usually based on the employee's length of service and salary, and it is often stipulated by the law, just like what I have mentioned before. Another one is the back wages incompatible with statutory separation pay. Back wages are the payment an employee is owed for the work they did in the past but were not compensated for, while statutory separation pay is the pay given to employees upon termination for authorized causes, meaning an employee typically cannot receive both back wages and statutory separation pay simultaneously. If an employee is awarded back wages, they may not be eligible for separation pay, and vice versa, depending on the legal and employment context. To give a glimpse or additional idea about statutory pay, it is mandatory financial compensation provided by the employer to the employees when they are terminated from their jobs for authorized causes as defined by labor laws. So this type of payment is meant to support employees during their transition to new employment. Let's go to introduction of labor-saving devices. As mentioned before, these are tools, machines, and equipments designed to reduce the amount of manual labor required to perform a task. Let's move on to redundancy. This is the creation of positions with functions related or similar to those of abolished positions that does not necessarily invalidate the declaration of redundancy. To better understand this statement, it only means that even if a new job positions are created within a company that have similar functions to those previously abolished positions, it does not automatically mean that the initial declaration of redundancy was invalid or unjustified. Furthermore, in declaring redundancy, there is also redundancy selection criteria. Number 1 is the less preferred status, or in simpler terms, these are temporary employees. Number 2 is the efficiency, meaning those that are not efficient in their jobs or field of works anymore. And lastly, the seniority, meaning those that are working longer in the company compared to the newbies. Next is the valid abolition of position and transfer to lower position, or the offer of lower position to redundant employee. So as the statement itself, it is very understandable that a company decides to eliminate a specific job role. And as a result, the employee who held that position may be offered a different job within the company, which is typically at a lower level or with different responsibilities. Say for example, if a company decides to eliminate a managerial position due to restructuring, the manager may be offered a supervisory role instead. So in this type, supervisory level is lower than managerial position. Next is replacing a regular employee with an independent contractor. This refers to the practice of terminating a regular employee and hiring an independent contractor to perform the same or similar duties. This could be a way of a company to reduce costs related to benefits, taxes, and long-term obligations to employees. However, it must be done legally and fairly. Contracting out a concessionaire involves outsourcing specific tasks or services to an external company or concessionaire. For example, if a hospital outsources its cafeteria services to an external food service company instead of employing staff directly. This also allows the company to focus on its core activities while the concessionaire manages the outsourced service. Good faith presumed only means that actions taken by employers are generally presumed to be in good faith unless proven otherwise. Next, we have invalid declaration of redundancy. It is a situation where an employer's declaration of redundancy is found to be invalid, often due to lack of genuine business reasons or improper procedure. For example, a company claims redundancy as a reason to lay off workers but continues to hire new employees for similar roles. So it suggests that the redundancy claim was not genuine, therefore it is considered invalid declaration of redundancy. Another one is redundancy in bad faith, hiring new employees while firing old ones. This situation occurs when an employer dismisses employees citing redundancy but simultaneously hires new employees for similar roles, indicating bad faith. Example, a company lay off several administrative staff claiming their roles are redundant but shortly afterwards hires new administrative staff. So it is considered redundancy in bad faith. Next, we have causes of retrenchment. Lack of work means there is insufficient work to justify keeping certain employees. This can happen if demand of the company's products or services declines. Another one is the business recession, meaning the business faced reduced revenue and must cut costs to survive. We also have basic requisites of valid retrenchment. First, who is to retrench? Employers must have clear, fair criteria for deciding which employees to retrench. This ensures the process is transparent and justifiable. A company might use performance evaluations, skill sets, and job relevance to determine which employees are essential and which positions can be eliminated. Lastly, the seniority right. So it refers to the principle that employees with longer tenurity may have preferential treatment during retrenchment. This can mean retaining senior employees over newer hires. Basically, in a situation where two employees have similar roles, the one with longer service might be retained while the newer employee is retrenched. That's it for the coverage of my discussion. Thank you.